Here we go. Here we go. Now we're live. Thank you, counsel. Good afternoon. This is the afternoon docket for March 7th, 2022 for the Kansas Court of Appeals. My name is Steve Hill. I've been designated by the chief judge of our court as the presiding judge for this panel. It's my pleasure and privilege, really, to be seated on a panel with Judge Anthony Powell and with Judge Amy Klein. All three of us are judges on the court with some years of experience, and we're anxious to hear your cases. The first matter that we have on our docket this afternoon is number 124034. It's entitled Terry Baker versus Lee Norman and others. Counsel, I'll have you enter your appearances here in just a moment. I would ask if you represent the appellant and if you wish to reserve some time for rebuttal, please let me know and I'll make sure that you get it. So I can tell you that we have read your briefs and we have received a research memorandum from our research staff concerning this case. And I think we're ready to go. Be prepared to answer some questions. We might have a question or two for you during your presentation. But 15 minutes isn't very long. And I suggest that you get right to it as you proceed with your argument. Because hit us with with your best shot so we can hear your best arguments first, is my advice. All right, with that in mind, for the appellant, please enter your appearance.
Please court, Linus L. Baker appearing on behalf of the appellant. We reserve 5 minutes.
That was 5 minutes, counsel?
Yeah, yes, Your Honor.
All right, you've got it.
Yes, may it please the court, Curtis Wired, Assistant Solicitor General, appearing on behalf of the state defendants, present ready for argument.
And that's the Secretary of the Department of Health and Environment, the Governor and the Attorney General, is that correct?
Correct.
All right, thank you. Mr. Baker, let's hear from you on behalf of Terry Baker.
Thank you, Your Honor. I'm going to start where I think the lower court started, which is the federal appeal, Baker v. USD 229, 10th Circuit case. And that case got dismissed without prejudice. That court said that the plaintiff appellant had not satisfied the injury in fact requirement, and went into some analysis about that. That petition, it was a 2019 petition, and it simply said Terry would like the option of sending Silo to a daycare. And they said that's not good enough. That's a someday kind of thing. And in fact, in their opinion at page 878, they conclude she has not identified any imminent enforcement and cannot do so because she has not alleged any attempt to enroll him in a child care facility. Had not alleged any attempt. All right. Well, so 2020 comes around and we can fix that. If you want attempts, we can get you attempts, and the attempts were made. The complaint on volume 2, page 416, talks about 4 attempts. Paragraph 38, in 2020, Terry has attempted to enroll Silo. Paragraph 38, Terry asked if Silo could participate. Paragraph 39, Terry has inquired of Jewish Community Center. 40, Terry has inquired of We Workshop. So all the things that they said in the pleading and factually, those were remedied in 2020 with these actual attempts. Now, they also referred to in footnote 6, I had raised equal protection, and I said that's relaxed on standing. and there's a First Amendment Establishment Clause. And they said in the footnote that I didn't raise it and that the Establishment Clause didn't raise that. So it was a pleading problem. But in this complaint, I pled all that. So for everything that they said was deficient or didn't happen, that was factually cured and pled. They made a curious statement in dicta. They said, well, we think that the Goss affidavit and the Attorney General has got this opinion, and we would predict that they'll let you enroll in light of that. That's what they predicted. Well, they were wrong. And why were they wrong? Well, because they have to do what the regulation says they have to do, which is you have to fill out this CCL 029 form. And that requires that you have to be this adherent to a religious denomination. That's what there's no ifs, ands, or buts about it. And I go into quite a bit of a parody in the briefing about how would that dialogue happen if it is what they said it is, that I could have this Miss Goss's statement like a coupon and present it. And then we go through that. But the problem, and if Goss has created a new rule and that's the new entry fee and that's the regulation, all you have to say is say it. Dispense with all this other. But she hasn't done that. There's been no new rule. These daycares don't know about this. And why would they? So the lower court, then she kind of transposed what happened with the school district. And school districts, of course, can decide how they want to handle religious exemptions under 72, 62, 62. And they said, well, the school district, they don't have to follow that. They can come up with their own vaccine exemptions, and that's what they did. Well, that doesn't apply over into the world of daycares. Daycares they don't have that kind of school autonomy. They have to follow the regulation. They are licensed based on that. They have to follow the statute. So they're apples and oranges. Excuse
me, Mr. Baker. Speaking of apples and oranges, before you leave the world of education, again, if I read this pleading correctly and your brief, you're saying that Terry cannot homeschool Silo because of state action. Could you explain that to me?
I don't think that's part of the appeal, Judge, but I can certainly speak to it. I didn't appeal anything on the school side. But if that makes that any better, I did not. And you don't have Blue Valley here. That part of the equation is over. So if it's a matter, I can talk to it, but it's not.
Well, thank you for clarifying that.
This is strictly on the daycare side,
right,
not the school side.
Okay,
so,
thank you.
And separate those. And you know what? That conversation actually goes to what I call the lower court's confusion, because I say she muddled all that together. She said, well, you gave a statement over to Blue Valley. Why can't you try to give the same kind of statement over here to the daycares? Well, it doesn't work that way. They don't have that kind of leeway to disregard what that statute says as opposed to what a regulation says. So, and in one way, they're right. Blue Valley said you can come to school, you can do that, do whatever you want. So didn't appeal it. And so that's where we're at. And so I've gone into great detail about these requirements that Kansas has. They're not unlike other states in which you have a religious accommodation, but just like the Boozman court looked at in Arkansas, same kind of accommodation, and they ruled, look, you can't do that. You're establishing religion on the one hand by saying you have to be this adherent to a religious denomination. And why is that? Why would you put something like that into a statute? Because they didn't recognize that you can have a religion of one. And they said, well, your religious beliefs aren't good enough unless you have to identify with some other brick and mortar, some denomination. And we'll recognize their religious beliefs. And if you can attach yourself to them and identify with them, then we'll let you have this religious accommodation. That's the thinking. And so this statute, this regulation requires Terry to say something that she is not. She is not an adherent of a religious denomination. She's not associated with them. And she doesn't need to. Now, the state and the lower courts seem to think they knew what Terry's religion was better. They thought she could say it, whatever, and she could do it. But she can't. And this is kind of like the Thomas in making parts for an army tank. And they said, well, now, Thomas, you've made parts for army tanks before, and surely now you can make one for a turret. And he said, no, I can't. And they said, yeah, you can, and we know better. Well, the Supreme Court said, look, Thomas gets to define his own religion and his own religious beliefs. You don't get to do that for him. And so Terry says, I'm not an adherent of a religious denomination. She's not. I don't need to say it. I can't say it. And they make me say it, and I'm not. And so now the injury is apparent. She cannot get daycare service. She cannot get youth services. She can't do any of those things.
Let me ask you this. In opposing your case, the appellees argue that this is now in the area of private action, and they should not be held responsible for what some private business does. Could you respond to that, please?
Sure. This isn't a contractor. This is a licensed daycare provider. So these youth programs are licensed. So if I want that, that's a benefit that I and the state is licensing that. So why would I sue We Daycare when they're going to say we have to follow the regulation? Your argument is not with us; it's with them. They make us do what we're doing. So we would come back to the same place. They are licensed, and so this licensing scheme that they have to impose upon us, the injury is traced directly to the regulation. So that's the cause of harm. I could sue all those people all day long, and you know what's going to happen. It's not our fault. We have to obey the license. Your problem is with the regulation. Sue KDHE and get your relief there. And that's what we've done. So it is a licensing scheme. So they are the cause of the injury because they have to obey that regulation. That's the traceable part of that.
Mr. Baker, may I ask you a question? As I see the record, there's an affidavit from Ashley Goss, who's the Deputy Secretary for Public Health, who oversees the licensing of child care facilities for KBHE, and she submitted an affidavit saying that a written statement by a parent or guardian to the effect that it's against their religion satisfies the statute. So that's their enforcement provision. Why isn't that good?
Because she hasn't told the daycares. She hasn't revised her CCL 029 form. So in other words, that would be great, Judge, if she conveyed that to all the daycares and said, hey, forget that CCL 29 form that makes these people check the box to say they're an adherent to a religious denomination. But she hasn't published it. She hasn't told a soul about it. So when I go to the daycares, they say, who's Ashley Goss? Who's she? Well, we've got a regulation, Mr. Baker. We've got this, we have to follow. And I go through it in the reply brief for how ridiculous that is. Well, call Ashley. She'll tell you. So it goes back to rulemaking. If Ashley wants to make that rule, and that's a new rule, no doubt. I mean, that simply blows up CCL 029. It blows up the regulation. Fine with me, blow it. And I'm asking you to blow it up. But if she wants to administrate that, then she needs to tell the daycares and the youth programs and all that you don't have to. In fact, I don't even know what you'd have to say. Hey, I just don't want to, I have a religion, period. So there's no guidelines, there's nothing, but that's the answer to that, Judge. And it's
Counsel, let me tell you, you're into your rebuttal.
okay. I'll quit right there. Unless you have questions, I'll quit.
I have one question.
Sure.
Counsel, just to clarify the record, did your clients actually show any of the daycare centers the affidavit from Ashley?
That I don't know. I know that when she asked, they said, no, you have to fill out the form. So whether that's a distinction without the difference, they all said the CCO 29 is what you have to do. So that's what you have to do.
So the answer is you don't know if you're.
I don't know, but I don't think it would. I don't know. All I know is what they required, and they said you have to fill out CCL 29. You know, if there's a new rule, then if Ashley's got a new rule, she ought to tell those daycares. But I don't know.
Thank you, counsel. You still have your rebuttal time.
Thank you, Judge.
All right, Mr. Wired, you're speaking on behalf of the appellees. You may proceed.
Thank you, Your Honor. May it please the court. The only issue in this case is whether the Bakers can establish traditional common law standing. The merits of the interpretation of the statute don't come into play until they can show that there is an injury, a cognizable injury, and that injury is fairly traceable to the state defendants.
Now, would you agree with me, counsel, that the Kansas rules are a bit different than the federal rules on this?
They're slightly different. The Kansas courts have not expressly adopted the federal rules, which have the additional element that the remedy or whatever the redress they're seeking can be obtained through a court. However, the Kansas Supreme Court recently emphasized in another standing case involving Mr. Baker that any injury or any alleged future injury must be concrete, particularized. I believe Justice Stegall wrote that opinion and emphasized that aspect of the federal law is reflected in Kansas law, and that's what's key here. I want to, since Mr. Baker started with the 10th Circuit case, I'll jump to the end of it here, where they said the court, in finding that they lack standing, said that Terry has not alleged any attempt or concrete plans to enroll the child in a non-accredited private school or a child care facility. So what's happened here is that there is an amended petition where the Bakers are trying to bump this argument down the runway to see if it will eventually take off. But in doing so, in bumping it forward, all they're doing is picking up the phone, calling these childcare providers and saying, and this is from the petition, quote, they asked if the child could attend being non-compliant with the vaccination requirements. They also alleged that, quote, Terry did not meet the statutory requirements of KSA 65-508. In other words, they conveyed their misinterpretation of the statute to the childcare providers and then ask a question that has an obvious answer in an attempt to manufacture, and that's the word that the district court used below, was manufacture an injury. And we know that this is a manufactured injury because, as Judge Powell referenced there, we have this affidavit that states clearly that KDHE would accept the Baker's statement of religious exemption as suitable for a child care center. Now,
well, he argues that that's not a rule. And so you could renege on that anytime you wanted to because it's just one person's opinion. What's your response to that?
Well, I mean, Ashley Goss has just as much right to interpret the statute as anybody else, as the Attorney General has. And I would note that the CCL language that he references mirrors the statute. So necessarily, anytime somebody asks for a religious exemption, it's going to require an interpretation of that language. So it's not rulemaking. It's just an interpretation of the plain language of the statute, which is also found in the regulation. And I mean, to that end, I mean, if we're going to get into the merits of the meaning of this statute, which this court doesn't need to do, this is purely a standing question. Denomination can be read broadly to mean Webster's defines it as a religious group. So it need not be a recognized brick and mortar ecclesial body. It could just as easily apply to a Buddhist, Muslim, member of a Baha'i faith. So again, the point is in all this is that the alleged injury is based on a misinterpretation of the statute. And the 10th Circuit stressed this, that the Bakers wish to argue a case based on their interpretation of the statute. Because others won't go along with it, they still want to push in just enough down the runway to get enough of an injury so that they can argue this legal issue that really there is no particular remedy that they want. And then I guess even if this court finds that there's an injury, the state defendants have not caused it. The Goss affidavit demonstrates that if they were denied access to a daycare facility, that would be the action of the daycare facility, not the state defendants. And then they go on, the Bakers assert that they can't then fill out the CCL form because it doesn't match their religious beliefs or how they frame their religious beliefs. But at that point, when we pointed out in the brief, they're harming themselves. They don't cite any authority for the point that they can just simply, that they're allowed to receive a religious exemption without even having to invoke it at that point. So it's either the child care provider is harming them or they're harming themselves, but it's not my clients. And then Judge Hill, to your point about the difference in the federal and state, I believe in Gannon, the Supreme Court did cite the federal standing standards as well. And under that, you have to, a court must be able to redress the alleged injury. The redress that's being sought here by the Bakers is an advisory opinion that they can use for who knows what purposes. Obviously, this is not the role of the court. It's meant to settle disputes with concrete injuries where there can be an actual remedy provided. So with that, we would ask that the court affirm the district court's order dismissing this case.
Well, let me follow up on that because I'm very sensitive about what our court can do in this situation. The only question that's before us is a dismissal based upon standing, correct?
Correct, Your Honor.
And there's nothing in that ruling at the district court that said a court cannot offer any relief in this situation. There's no finding by the court that says that, is there?
Your Honor, I reread the district court order. I don't remember if there was, I don't think there was a reference to this additional federal redress provision.
So if we affirm the district court, then we are not tacitly then adopting the federal view of standing that says clearly that the controversy has to have something that a court can do to remedy. Is that correct?
Yes, Your Honor, I think that's correct. I think the silence wouldn't suggest that you're tacitly adopting it. And in fact, I mean, the court could expressly note that although the Kansas Supreme Court has previously recognized this additional federal standard in certain cases, i.e. Gannon, it hasn't been expressly adopted by the Kansas Supreme Court.
But the facts in Gannon are not similar to this.
No, Your Honor.
Mr. Wire, what are you saying that Ms. Baker would have had to do here? Would they have had to apply for a space in the daycare and fill out the form and then be rejected because the daycare wasn't satisfied with the answer that was given? Is that what you were saying is required here?
I certainly think there's something more than what's been done here, which is apparently a phone call where they've conveyed their misunderstanding of the statute and the regulation. Something more concrete, more particularized. I think in this area of the law, it's hard to draw firm lines, as this court well knows. But I would certainly say that, yeah, if they submitted an application and the child care provider then said, well, you don't meet the definition this isn't available to you, then you're much closer to a concrete, particularized injury. But again, you still have to account for the fact that there's this affidavit out there that states that their written religious exemption to the schools would be enough here.
Mr. White, what's the agency's enforcement policy on something like this, where a daycare is claiming a regulatory requirement to deny the admission of a child into their daycare, and they're incorrect about that? Does the department then engage in an enforcement action of some kind against the daycare to say, no, you're wrong, you're misinterpreting, this is not our policy, you can admit them? How does that work?
Well, based on my personal experience with children in daycare, oftentimes what they do is they speak to KDHE. I don't have the precise legal process laid out here for you, but they communicate with KDHE about the requirements for admitting a child. Now, I don't want to make any, based on my just personal experiences, I don't want to make any broad statements of allegations of law here, Your Honor.
Well, I guess your answer makes me think that there's some material, that there might be some material fact issue here, because if you can't really tell me for sure, and we apparently there's nothing in the record. I haven't gone through the record at length that shows what the department does in a situation where there might be some allegation that they're not applying or following the regs, or some enforcement policy of KDHE. That's, I guess, a concern I have. Maybe we don't even get there here, but that question is coming to my mind here. Because one of your defenses is it's not just that they haven't shown injury. You're saying, well, you can't sue the state because the state isn't the one that's doing this. It's the daycare that's doing this.
Right, Your Honor. And to that point, I would say analytically, you're getting at the second point, which is whether it's fairly traceable to my clients. Before you get there, you have to determine whether there was ever an injury. So if you don't find that there's an injury, you don't have to concern yourself with this question. And I think we make a pretty compelling argument that there has been no injury here. But I recognize, Your Honor's concern here. We talk about in the brief how if they would just had reached out to KDHE, the so-called controversy would easily be resolved, because we know from the Goss affidavit that KDHE interprets the statute this way, interprets this plain language, which is in the statute and in the regulation, this way. Unless there are any other questions, I would ask that the court affirm the district court's decision below.
Any other questions, counsel, or any of the judges? Okay, thank you very much. Now, Mr. Baker, you requested 5 minutes of rebuttal, and you've got it.
All right, thank you, Judge. Let's start back with the 10th Circuit. They never said I sued the wrong party. They never said I had to have a daycare there to have an injury. So we had KDHE there. That was enough. They never fussed with that part. Let's go back to what counsel said. He said, if you could allege that they actually told you that you had to be this adherent, he said that would be an injury. Well, guess what? Paragraph 38, Terry asked if Silo could participate in a Johnson County, Kansas parks and recreation outdoor camps in summer and winter. Terry was told that Silo had to be vaccine compliant, or that Terry meet the requirements of being an adherent of a religious denomination whose teachings are opposed to vaccinating. Well, there it is. She was told. There wasn't any, let me not ask. They said it. Terry inquired of the Jewish Community Center. The director stated Silo must be vaccinated to participate. There was no exemption given to Terry as a way to have Silo participate. This idea that they're not following the regulation is kind of crazy. They are specifically told in the regulation, we give you a mandatory form called CCL 029. That is the mandatory form they are required to use. And they use it. And that form, it's a check box. Check the box, I am an adherent to a religious denomination. So the whole idea here is they are following the regulation. They are doing exactly what they're told to do. The injury flows from KDHE. Quit telling these daycare centers they have to do that. And because look, if you just turned around, we sued daycare, they're going to turn around and say, KDHE makes us do it. They're the ones that are causing your injury, not us. We're just following the rules. But here's the more important point. This Goss affidavit, they have to make a rule. They have to publish this. The regulation specifically says what it requires. Now, I don't know where Goss got her authority, but I don't think she can come back and change that regulation and say, if I were a daycare operator for a day, I would take any old, forget about CCL 29. We'll tell that to these daycare operators that could have their license taken away. So the fix to all this is that language. Don't have that language in there. Don't make these daycare operators and youth programs make these parents be something that they're not. It's a real easy fix. And we can show, I mean, if you want me to are you guys following CCL 29? Yes, we are. And do we have to follow it? Yes, we do. And here's the thing, nobody knows about this Ashley Goss coupon. They don't publicize it. I guess we're the only ones in the world that know about it. So the public out there, they have no idea that they don't have to be an adherent to a religious denomination. No idea. And nobody's publishing it. That's the whole idea about a regulation and requirement to have it published. If they want to change it, get them to publish a new rule.
Mr. Baker, can I interrupt you for just a moment?
Sure. No, you're the judge.
What difference does it make whether they change the regulation or whether they take an enforcement decision and say, no, you can go ahead and admit Ms. Baker's child to your daycare program on the stated reason that they've given, and that's good enough. To your client, that's all that matters. What the regulation says, as it may or may not apply to anyone else, is irrelevant to your client, right?
You know what?
The goal is to have your client's child admitted to these programs with the exemption that they're seeking and on the grounds that they're seeking.
Well,
that's what they want, right?
Well, yeah, and I think Judge Hill brought it up. This coupon they're waving out there, that can go away tomorrow, but let's put that aside for a moment. The idea is that didn't happen though, Judge. The daycare operators denied it. All right. So I get it. And I tell you this, if that's the new rule and I don't have to wave this coupon around all the time, just tell these daycare operators they don't have to do what the regulation says. Fine. But nobody's telling them that. And nobody's telling any other family out there in the Kansas that you don't have to do this. So that's a problem.
Counsel, that concludes your time, unless there are any other questions from the judges, anything from the panel?
No.
All right, thank you both for a very interesting argument. We'll take the case under advisement and issue an opinion as soon as we can on